Hello, my name is Ashish Pudasaini. In our digital age, every click, post, and mistake remains permanently accessible. The right to be forgotten emerges as an essential protection, allowing individuals to reclaim control over the digital identities. But does the right enhances personal privacy or limit freedom of the expression?
In 2014, Europe's biggest landmark cases, Google Spain versus AEPD, formally introduced the RTBF. It grants the individual the right to request the removal of outdated and irrelevant personal information online, later codified under GDPR Article 17, making a significant step in digital privacy rights.
While widely supported across Europe, Argentina, India, and South Korea, the United States remains resistant, citing free speech protection under the First Amendment. This disparity creates a fragmented digital privacy landscape globally, highlighting the urgent need for the international consensus.
If your organization still falls short of compliance, it's by no means too late to take steps to ensure your compliance with the law. So, what do you need to do? First, it's important to understand some of the terminology the regulation uses. The GDPR defines personal data as any information relating to an identified or identifiable natural person, including names, identification numbers, location data, online identifiers, and one or more factors specific to their physical, physiological, genetic, mental, economic, cultural, or social identity. Processing is any operation or set of operations that's performed on personal data, whether by automated means or not. Data processors are responsible for processing personal data on behalf of data controllers, and data controllers determine the purposes and means of the processing. Data controllers are responsible for and must demonstrate compliance with 6 data processing principles. Personal data must be processed lawfully, fairly, and in a transparent manner, collected for specified, explicit, and legitimate purposes, adequate, relevant, and limited to what is necessary, accurate and, where necessary, kept up to date, retained only for as long as necessary, and processed in an appropriate manner to maintain security. There are also 6 lawful bases for processing. Except for special categories of personal data whose processing is prohibited except under certain circumstances, personal data can only be processed if it's necessary to meet contractual obligations entered into by the data subject, to comply with the data controller's legal obligations, to protect the data subject's vital interests, for tasks in the public interest or exercise of authority vested in the data controller, or for the purposes of legitimate interests pursued by the data controller, or if the data subject gives their explicit consent.
We examine RTBF through utilitarianism, which promotes the actions offering the greatest benefit to society. RTBF minimizes psychological harms, enhances social inclusions, and fosters digital fairness, significantly outweighing potential drawbacks related to information accessibility.
Persistent negative online content deeply affects mental health. Few research center studies shows a user experiencing depression, anxiety, and social exclusion due to outdated or irrelevant harmful information. Right to be forgotten provides crucial protection against these ongoing digital traumas.
People deserve second chances. RTBF enables genuine rehabilitation by reducing digital remembrance of the past mistakes. Juvenile records and errors should not dictate lifetime consequences, allowing an individual the opportunity for genuine transformation and integration.
Right to be forgotten addresses inequality effectively. Marginalized communities disproportionately suffer online harassment and reputational damage. By offering accessible digital right protection, Right to be forgotten ensures fairness and equity in managing online identities and reducing digital discrimination.
Critics argue RTBF risks censorship or historical distortions. However, Existing legal frameworks like GDPR explicitly protect critical public interest and journalistic integrity. Comprehensive human algorithmic review processes ensures RTBF balances privacy rights with responsible public accountability.
We have explored why right to be forgotten profoundly matters. Now let's dive deeper into the strongest argument against
RTBF, carefully examining and responding to each concern.
We conducted an in-depth analysis of big tech's privacy policies and dug deep into what they were doing when it comes to GDPR's right to be forgotten. Here's what we found. The rules and explanations in big tech policies are often very complicated, making it challenging for people who don't have a degree in law or software development to understand what the heck is happening with their data. Moreover, it's difficult for people to understand the implications of data collection and processing fully. Big tech companies are accused of gathering more information than necessary, sometimes invading people's privacy by knowing too much about their online activities. Users often feel like they have little control over how their data is used. Privacy settings provided by these companies can be complex and challenging for users to navigate, limiting their ability to have control over their privacy. The policies seem to change often, and users may not be aware of these changes unless they sift through pages upon pages of documents. Big tech companies have encountered legal challenges and allegations of violating privacy laws, contributing to concerns about the effectiveness of their compliance with GDPR.
Some worry RTBF undermines historical integrity by enabling the removal of uncomfortable truths. In reality, RTBF only de-indexes personal information that has lost relevance without deleting the original records. Important historical and public accountability documents remain fully accessible, preserving the integrity and transparency of the public records.
Right to be forgotten is also a matter of digital equity. Marginalized groups like racial minorities, LGBTQ people are victims of revenge porn, face the harassment consequences of online exposure. They often can't afford expensive reputation management tools. Right to be forgotten create a fair, accessible path for everyone to protect their digital identity no matter their background or income.
In today's interconnected world, the RTBF isn't merely about a policy. It's an embodiment of compassion and justice. Let's advocate for comprehensive policies worldwide that uphold human dignity, provide second chances, and secures the balanced digital justice.
So here is why right to be forgotten matters, because people deserve second chance, because your past should not define your future, and because comparison and progress should be the value that guide our digital world. So right to be forgotten gives us the chance not to rewrite the history but to let people move forward. Right to be forgotten maximize well-being by minimizing harm, allowing people to grow beyond their past while protecting their public's right to important information through strict rules and exceptions. So the European Union's law, like Article 17 of the GDPR, shows us how this can work. Individual can request removal, news article, criminal record, or public interest data are protected. Each case is reviewed by both algorithms and human expert. This is not censorship, by the way. It's smart and selective. Didn't erase history. The original article still exists. It just no longer dominates his search result. That's the key idea. The de-emphasize, not delete. So right to be forgotten gives us the chance not to rewrite the history but to let people move forward. Thank you.
Thank you for engaging with this critical issue. Join us in supporting the right to be forgotten, a vital step towards the digital empathy, dignity, and fairness for everyone involved.